Okay, this court has had the privilege of considering the issues being raised, mainly the applicant hearing, whose main concern is that despite being arrested and held in custody, he has taken the steps, i.e. the ODPP or DCI, quite some time to charge them or to give clear indications on whether or not they are persons of interest, whatever evidence they have against them can sustain a charge or conviction. On these issues, the court's role is very limited to protecting their rights to freedom and liberty as envisaged in the Constitution, which this court will do without fear or favor. In that regard, this court will not be seen to make any orders in regards to operations, advice, and decisions made by independent officers, i.e. the ODPP and the DCI. I can only extend my bail terms and conditions for another 6 months, which allows the two officers time to decide whichever way they will pursue. It is very unfortunate. It is very unfortunate that the applicants herein will have to live with the mental anguish of waiting. But to this court, their liberty and freedom is sacred and secured. It's sacred and secured by the orders the court had issued earlier, and which it has extended, it has extended here in above. Yes. Taking this court to the second issue of perjury. It is true the two officers appeared and on oath stated that no spyware or applications were installed in the said gadgets. What is not clear is whether or not they had knowledge of such, or if someone in their offices did that without informing them. It is only prudent that the two do appear and furnish in confidence the particulars of who handled the said gadgets in their offices, or the process they underwent, as reports from Introvert Technologies indicate that, i.e., in relation to Mark Denver Kurubu, my phone explorer was installed by a known user while the device was outside of Mark Denver control. In relation to Wambugu, the report indicates that on the 21st of May 2025 at 5:36 p.m. UTC Flexi Spy V533 was installed on the phone. Flexi Spy is a commercial spyware application that grants the installer of the application full administrative access to the target device. In relation to Adagala, it was opined that a known user opened a cap-out program in the phone on the 21st May at 14:20 9 p.m. UTC. Same to the other accused. From the above consideration, it is only again prudent that as a rule of ODR terrain pattern applies to all the two officers from DCI should be given, the two officers from DCI should be given an opportunity to reply on the issues raised on those reports for the court to make a determination as to the rights, as to the infringement of rights to privacy, which again is another constitutional right. It's another constitutional and fundamental right that must be protected jealously. The court will not want to make any finding or observation before the office of DCI responds, as the issues herein cannot simply be overlooked or wished away casually. The court is alive to the sensitivity of this case, the issues of security, the issues of national security and stability of the nation. It summons it will therefore summons the two officers, and as it's commonly stated that from a little spark of fire bursts a mighty flame, the two officers to appear to respond to the report, to appear and respond to these reports. What do you have in mind? It is a while them to come and respond to these reports so that we know the trend.
Your Honor, I'm happy to take any dates on the court's convenience.
Here on the 7th
of January.
Yes.
I'll be present. Yes. Yes.
On the 7th of January, 2026. I hope I've covered bulk of it. Is there anything I've not covered?
Your Honor, the only pending issue has already been addressed on the perjury. So I think that addresses the concerns.
Yes.
Yeah.
So once they come and we're able to track that, then I'll do my finding on that.
Most obliged.
Yes.